Hello, Maciej.
Hello, Michał. Hello, everybody. Welcome to Chamber Expert Focus Technology. Update for Poland, because today is the Data Protection Day. So we have prepared for you some hopefully reasonably interesting news concerning mostly Poland, but not only. Let's go, which is not that easy because the presentation was okay. Who's going to speak? My name is Maciej Gawroński. I'm a Polish attorney at law and Polish and EU technology lawyer with some accomplishments, nice books, and also some awards. But we will get to it when discussing, well, shortly, our firm.
My name is Michał Ćwiakowski. I am a partner in GP Partners, responsible for banking and finance regulatory, data protection, and technology practice.
Yeah, and he's also ISO 27001 lead auditor, so it's information security standard. And this is why we do cybersecurity and all sorts of
Always forgetting to mention.
Yeah, he always forgets to mention. Michał. Okay, Michał. So the last introduction is about the firm. We would like to draw your attention to the best-selling books we've written. One is Guide to the GDPR. It was Polish bestseller in 2018 and 19. The best-selling book, legal book in the year, #1. And now we also have another one, which is going to be published in English because the Guide to the GDPR has been published in English. It's a little book about writing pleadings, and I hope the English version will be ready soon, and keep up with us to know about it. We also received the award of the Polish Data Protection Office, so authority. And now maybe let's tackle some data protection news. So the first one is not exactly about Poland, but it's something interesting for every professional doing cybersecurity and privacy. So it turns out that the perception of privacy regulations is much better in 2022, or was much better, than in 2021, because Accenture has made a survey with 178 CIOs or CSOs and CEOs, and it seems as they believed in 21 that only over 20% believed that regulations are beneficiaries. So now over 70%, like 74%, believes that regulations actually contribute positively to the cybersecurity of their organizations. Not that they really want to attract control from a regulator, nevertheless, they appreciate.
Yeah, now time to move on to our local specificity, local specifics. First, we would like to start to freshly released by the Polish DPA control plan for 2023. We've got 3 key points. Well, this time comparing to the previous control plans, DPA does not focus on specific sectors, but this time it focuses on a specific
types of processing.
That's right. So the first, I would say, relates mainly to the public sector, which is data processing in Schengen and visa information system. But 2 and 3, I suppose, will be more focused on the private sector, which is data processing within mobile applications and web applications. It also, well, it is going to focus on securing personal data as well as sharing of personal data by those who run the mobile applications. I wonder whether it's an outcome of Schrems ruling and NOIP complaints, which refer to such.
Maybe we'll get to it. What I can add to this particular topic is that so there was some internal discussion within the authority whether to publish the control plan they have decided to do it nevertheless, and we are praising them for that because this is building trust with the regulator, and this practice of actually letting know what they are focusing on for a particular year is a very good practice.
Yeah, so as we mentioned, data transfers, long story short, in July 2020, we had a famous Schrems 2 ruling. Then shortly after
Schrems 2, which is invalidation of privacy shield, and then also there was standard contractual clauses where, well, they were not invalidated, but the logic behind was undermined.
That's right. Then shortly after, we had 101 complaints filed by Noip Foundation.
Yes,
across Europe, different DPAs. Then we got the famous EDPB guidelines.
EDPB guidelines or recommendations, I think, for transfers of data, which like totally disregarded the principle of not proportionality, but actually the principle of risk-based approach to data processing upon which the GDPR was built, nevertheless.
Fully agreed. Now we have a few rulings across the EU. Some DPAs decided to declare transfers to the United States invalid. Some of them actually refused to issue meritorical decisions. But yeah, this is the state, so only a little part of the complaints has been resolved so far.
Yes, and well, we know that currently a new adequacy decision is incoming. And coming back to Poland, so the Polish Data Protection Authority and president of the Polish Data Protection Authority wasn't very predatory in his and theirs approach to topic of actually using cloud services, because it's very tightly related, and using various technology services. And they haven't finished, because there are also at least two or three complaints concerning Poland. And well, we know for this reason or another. So anyway, the thing is that the approach is pragmatic and is reasonably business friendly. We move on, Michał?
Yeah, I think so.
Okay. So now something which is particular, it's exotic, particularly attributed to Poland, and this is that Polish administrative courts have a very interesting views on some categories of personal data, which they actually do not regard as data, as personal data.
That is correct. On the slide that you can see, we have placed the most significant rulings and most significant,
most peculiar,
maybe, yeah, you're right. Rulings regarding, let's start, car plates. What our administrative court decided? Well, they decided that the car plates, they identify cars,
not
person, and as such, data related to things that does not related to things, not to the persons, do not
constitute data, but personal data. The thing is actually built because the city of Warsaw, they have these parkometers, and they somehow freed themselves from the GDPR regime with that ruling. But we are not happy with the ruling because it's absurd. So I, in my own name, personally filed a statement of claim with the civil court, and I asked the court to go to the European Court of Justice to do what? To ask preliminary question. Yeah. So and the Polish Data Protection Authority, called PODO, they said that they will join me in the fight for, for reason, I would say. But let's move to the next one.
Another example.
Even worse.
Mobile number. the court decided that if the mobile number is processed by the controller without any other identification data, then it is not personal data. The context, I think, is very important here too, as the controller was a telemarketing company using these mobile numbers purely for the forbidden market.
Yes, so this is very bad, and probably we've already discussed it with the Data Protection Authority. We will do the same, so we will attack this particular ruling. But then there is the last one, and the last one is slightly different.
Yeah, I would say that, well, considering the ECJ rulings as well as positions of various data protection authorities across Europe, we more or less thought that IP addresses should be and are considered by these entities as personal data.
Yeah.
However, once again, our courts have ruled out differently. They decided that it cannot be considered personal data per se unless it is determined that the controller is actually
capable of identifying with this data particular persons,
more or less by himself.
Yeah, because the thing is here, and actually I like this ruling. It's I am a big critic and very critical about ID fashion ruling of the European Court of Justice, where the court decided that by running a fan page on Facebook, this particular entity became co-controlling data with Facebook. I'm making laugh that I'm not a co-controller of data with Mark Zuckerberg. And this is actually the logic applied by the Polish court to this particular case. Probably it was built upon and considered concerned Google Analytics. We're not sure 100%, but most likely.
Case, yeah.
And well, in this regard, it actually corresponds to a recent decision of the Agencia de Protección de Datos Personales, so the Spanish regulator. Are we moving on?
Yeah.
I also have I have a joke about it. So maybe let me. So it's very, but I like it very much. So there is this Jewish couple, and they're getting divorced in front of the rabbi, and so the wife complains about the husband, and the rabbi says, "Well, you are right." Then the husband complains about the wife, and the rabbi says, "You are right." But then somebody from the public stands up, "But Rabbi, it's not possible that he's right and she's right." And the rabbi says, "Yes, you are right as well." And this is actually a good example that this logic, multi-value, is actually very reasonable.
All right. Other curiosities of our, again, local specifics of the personal data protection. Our DP's approach to personal ID numbers, where it's dualistic, right?
Yes,
you agree.
I mean, so the Deep Data Protection Authority is very protective of PESEL, is the Polish name of the unique identification personal number, because when somebody knows somebody's name in PESEL, various bad things may happen. It may be kind of identify and the identity theft, and this is fine. However, at the same time, PESEL, this ID, exists in a public space on the internet, and some of it is, well, it's even built into the public infrastructure of Polish qualified electronic signatures. So whenever you're signing here in Poland with your QES, you are disclosing your PESEL. So it's something to be dealt with and more complicated.
Well, if you would visit the website that holds the entries to the court registry of our law firm, you would easily find our identification numbers.
But the practical take from this particular duality is that if you lose PESEL's numbers, so there is a breach and you lose these numbers, you disclose them, so you better notify not only PWODO, so the regulator, but also the affected persons. so data subject.
Fully agreed. We already have, just to mention the last thing on the slide, we already have a series of fines imposed on the controllers that failed to notify not the data subjects, but our DPA due to their low risk assessment.
Yeah. So you better notify than not notify the regulator, or else, in this case, else is a fine.
Another areas of focus of the Polish DPA. The first, data processing entrustment. From our experience, this is one of the things that DPAs always checks when controlling data controllers. Well, it focuses whether it verifies whether controllers apply in a accountable and proper manner supervision over data processors.
Yes, so this is important that this Article 28 is not only on paper, but also enforceable.
Again, we had a few fines imposed already.
Article 28 of the GDPR, to which, by the way, I have contributed.
That's right. And another interesting thing I think is data retention and DPA's approach. We think it's probably the same in other European countries, that controllers widely apply the limitation period for consumer claims as this ultimate term for data retention.
Yeah, well, limitations in customer claims, as well as sometimes also tax prescription or limitation. But
this is not appreciated by the Polish DPA.
Yeah, because according to the Polish DPA, the question concerns how likely from the set of data is a certain claim. How likely is that there will be a claim concerning this particular data, and usually when there are no claims, they believe that data should be deleted earlier. However, I remember a judgment which somehow validated this prescription approach, but just know that it's not like Polish courts usually overturn decisions of the Polish Data Protection Authority. Not at all. Mostly they uphold those decisions. So it seems like our 15 minutes is over. What we would like you to remember, just follow us, maybe personally, maybe our law firm profiles on social media. We sometimes share interesting news and insights, and also when there will be this new book on communication in writing, when it's available in English, you are more than welcome to order it and see how funny it is and useful.
Thank you very much.
And bye-bye.
See you next time.